You walk into a gun shop in New Mexico. You want to buy a handgun for home defense because there's been a string of burglaries in your neighborhood. You fill out the paperwork. You pass the background check. The dealer says, "Great, come back in 7 days and you can pick it up." 7 days. Not because there's a problem with your background. Not because the system needs more time. Just because the state says you have to wait. It's called a cooling off period. The idea is to prevent impulsive purchases and crimes of passion. But in December 2025, the 10th Circuit Court of Appeals said that's unconstitutional. The court struck down New Mexico's 7-day waiting period in a case called Ortega versus Grisham. And this isn't just a win for New Mexico. It sets a precedent that could kill waiting period laws across 6 states. And it's a massive victory for Second Amendment rights. Quick question before we continue. Are you subscribed yet? Because what I'm about to reveal affects gun buyers in New Mexico, Colorado, Utah, Wyoming, Kansas, and Oklahoma. And waiting period laws in other states are now vulnerable. Hit that subscribe button right now so you never miss updates on court decisions that expand your gun rights. Here's what just happened that you need to know about. In 2023, New Mexico passed a law requiring a 7-day waiting period for all firearm purchases. The law said that after you buy a gun, there's a mandatory 7-day delay before you can take possession. The stated purpose was public safety. The legislature said waiting periods reduce gun suicides and impulsive gun violence. If someone is in a crisis or angry, making them wait 7 days gives them time to cool off and reconsider. That's the theory. But gun rights groups immediately sued. They argued the waiting period violates the Second Amendment. The case is Ortega versus Grisham. Grisham is Michelle Lujan Grisham, the governor of New Mexico. The plaintiffs argued that if you have a constitutional right to keep and bear arms, the government can't make you wait 7 days to exercise that right. The case went to federal district court first. The district court sided with New Mexico and upheld the law, but the plaintiffs appealed to the 10th Circuit Court of Appeals. And in 2025, the 10th Circuit reversed. The court said New Mexico's waiting period is unconstitutional. The court applied the test from the Supreme Court's decision in New York State Rifle and Pistol Association versus Bruen. Bruen said that gun regulations must be consistent with the nation's historical tradition of firearm regulation. If there's no historical analog for a law, it's unconstitutional. The 10th Circuit looked at history. They asked, is there a historical tradition of making people wait to buy guns? And the answer was no. Historically, if you wanted to buy a gun, you bought it and took it home. There were no mandatory waiting periods. Some states had licensing schemes that took time to process. But those were different. Those were about verifying you were qualified to own a gun. Waiting periods are different. They delay possession even after you've been approved. The court said there's no historical precedent for that. Therefore, New Mexico's law fails the Bruen test. The law is unconstitutional. The waiting period is struck down. New Mexico's Attorney General asked for what's called an en banc review. That means the entire 10th Circuit, all the active judges, would rehear the case. But in December 2025, the court denied that request. The original decision stands. The 7-day waiting period is dead. And this is final unless the state appeals to the Supreme Court, which is unlikely. So what does this mean? As of December 2025, if you're in New Mexico, you can buy a gun and take it home the same day, assuming you pass the background check. The 7-day wait is over, but the implications go way beyond New Mexico. The 10th Circuit's jurisdiction covers 6 states: New Mexico, Colorado, Utah, Wyoming, Kansas, and Oklahoma. This decision is binding precedent in all 6 states. If any of those states tries to pass a waiting period law, it will be struck down based on this ruling. Colorado has been talking about a waiting period. Not anymore. This case just killed that before it even started. Let me give you a real-world example of why this matters. Imagine a woman named Jessica. Jessica lives in Albuquerque. She's a single mother. She works nights. Her ex-boyfriend has been stalking her. He's shown up at her house. He's sent threatening texts. She's filed a restraining order, but it's just a piece of paper. Jessica decides she needs a gun for protection. She goes to a gun shop. She picks out a pistol. She fills out the form 4473. She passes the background check. The dealer says, you can pick it up in 7 days. Jessica says, 7 days? What if he shows up tonight? The dealer says, sorry, it's the law. Jessica has to wait. She goes home unarmed. 3 days later, her ex breaks into her house. Jessica calls 911. The police arrive 15 minutes later. By then, it's too late. Jessica was defenseless. She could have had a gun on day 1, but the state made her wait. That's the problem with waiting periods. They assume everyone buying a gun is a potential criminal who needs to cool off. But what about people who need a gun right now for legitimate self-defense? Waiting periods disarm the victims. If you're finding this helpful so far, imagine what you'll learn in my next video where I break down which states still have waiting period laws and which ones are most vulnerable to being struck down after Ortega versus Grisham. Subscribe right now so you don't miss it. Now let's talk about the legal reasoning in more detail because it's important. The Tenth Circuit's opinion focused on the Bruen test. Bruen established a two-step framework. Step 1. Does the regulation burden conduct protected by the Second Amendment? If yes, move to Step 2. Step 2. Is the regulation consistent with the nation's historical tradition of firearm regulation? To answer Step 2, courts look for historical analogs, not identical laws, but laws that are relevantly similar in how and why they burden the right. The Tenth Circuit said New Mexico's waiting period clearly burdens Second Amendment conduct. It delays your ability to acquire a firearm, so Step 1 is satisfied. For Step 2, the court asked, is there a historical tradition of waiting periods? New Mexico pointed to colonial-era laws that required licenses or permits to carry guns in certain places. But the court said those are different. Those laws were about who could carry and where. They weren't about delaying purchases for everyone. New Mexico also pointed to 20th century waiting period laws. Some states passed them in the 1920s and 1930s, but the court said that's too late. The relevant time period for historical analysis is the Founding Era and the Reconstruction Era, roughly 1791 to 1868. Laws from the 1920s don't count as historical tradition. The court found no evidence that governments historically imposed waiting periods on gun purchases. Therefore, the law has no historical analog. It fails the Bruen test. It's unconstitutional. The state argued that waiting periods serve an important public safety purpose. They cited studies showing that waiting periods reduce gun suicides. But the court said that's irrelevant under Bruen. The Supreme Court has said you can't justify a gun regulation just by pointing to modern public safety benefits. You have to show it's consistent with historical tradition. New Mexico couldn't do that, so the law falls. Now, quick legal note. This is educational information, not legal advice. If you live in a state with a waiting period and you want to challenge it, consult with an attorney who specializes in Second Amendment law. Every case is different, and courts in different circuits might rule differently. Get professional legal counsel. Now, let's talk about what this means for other states. California has a 10-day waiting period. Hawaii has a 14-day waiting period. Illinois has a 72-hour waiting period for handguns. Florida has a 3-day waiting period. Rhode Island has 7 days. Are all of these now unconstitutional? It depends on the circuit. The Tenth Circuit's decision is only binding in the Tenth Circuit, but it's persuasive authority everywhere else. If someone in California sues over the 10-day wait, they'll cite Ortega versus Grisham. They'll say the Tenth Circuit already decided this issue and found waiting periods unconstitutional. The California court doesn't have to follow that, but it's a strong argument. And here's the thing. After Bruen, a lot of gun control laws are falling. Courts are striking down laws left and right because they don't have historical analogs. Waiting periods are vulnerable. They were always based on modern policy arguments, not historical tradition. So Ortega versus Grisham is likely just the beginning. We're going to see more challenges to waiting period laws in other states. And a lot of them are going to lose. Let me give you another example. Imagine a guy named Tom. Tom lives in Colorado. Colorado doesn't have a waiting period yet, but the state legislature has been considering one. Anti-gun groups have been pushing for a 7-day wait. But now, after Ortega versus Grisham, the bill is dead on arrival. If Colorado passes a waiting period, it will be immediately challenged. And the challengers will win because the 10th Circuit has already ruled on this exact issue. Colorado is in the 10th Circuit. The precedent is binding, so the legislature won't even bother passing the law. Ortega versus Grisham just saved Colorado gun owners from a waiting period they never had to experience. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these updates first. Click subscribe. Now let's talk about the dissent, because there was one. Not all the judges on the panel agreed. One judge dissented, arguing that waiting periods do have a historical basis. The dissent pointed to laws that required licenses or permits, which inherently created delays. If you had to apply for a license and wait for approval, that's functionally a waiting period. But the majority disagreed. They said licensing laws are about qualification. You're waiting to prove you're allowed to own a gun, but once you're approved, there's no additional delay. Waiting periods are different. They impose a delay even after you've been approved to buy a gun. That's what makes them unconstitutional. The dissent also argued that waiting periods are a reasonable regulation to prevent impulsive violence, but the majority said reasonableness is not the test under Bruen. The test is historical tradition, and there's no tradition of waiting periods. The dissent lost. The majority opinion is the law of the 10th Circuit, and it's a huge win for gun rights. Now let's talk about the practical implications. If you live in New Mexico, what changed? Before Ortega, if you bought a gun, you had to wait 7 days. Now you can take it home the same day, assuming the background check clears. The background check itself can take a few minutes to a few hours, depending on how busy the system is. But once it clears, you're good to go. No waiting. If you live in Colorado, Utah, Wyoming, Kansas, or Oklahoma, nothing changed yet because those states don't have waiting periods. But Ortega protects you from future laws. Your state can't pass a waiting period without it being immediately struck down. If you live in a state outside the 10th Circuit, Ortega doesn't directly affect you, but it's ammunition for legal challenges. If you're in California and you hate the 10-day wait, you can sue, and you can cite Ortega as persuasive authority. Now, let's talk about the timeline of this case because it shows how long these fights take. The New Mexico waiting period was passed in 2023. The lawsuit was filed almost immediately. The district court ruled in 2024, upholding the law. This information could literally save you 7 days the next time you want to buy a gun in the 10th Circuit. Subscribe now because my next video breaks down every state is waiting up period law and which ones are most likely to be struck down next. Hit that subscribe button. Now let's talk about what gun control advocates are saying, because they're furious about this decision. They argue that waiting periods save lives. They point to studies showing that states with waiting periods have lower gun suicide rates. They say the 10th Circuit is ignoring public safety in favor of an extreme interpretation of the Second Amendment. But here's the response from gun rights advocates. First, the studies on waiting periods are contested. Some show a benefit, others don't. And even if waiting periods reduce suicide, that doesn't make them constitutional. The Constitution protects rights even when exercising. Those rights has risks. Second, the Bruen test is clear. You can't justify a gun law just by saying it's good policy. You have to show it's consistent with historical tradition. Waiting periods aren't, so they fall. And third, waiting periods don't just affect suicidal people. They affect everyone, including people who need guns for immediate self-defense. Like Jessica, in my earlier example, disarming victims to theoretically save potential suicides is a bad trade-off. Now, let's talk about what happens next. Will New Mexico appeal to the Supreme Court? Probably not. The Supreme Court only takes a small percentage of cases. And this case is fairly straightforward. The 10th Circuit applied Bruen correctly. There's no circuit split. Other circuits haven't ruled differently on waiting periods yet. So there's no compelling reason for the Supreme Court to take the case. That means the 10th Circuit's decision is final. Waiting periods are unconstitutional in the 10th Circuit. But other states with waiting periods are watching. California, Hawaii, Illinois, they're all waiting to see if they get sued. And when they do, they'll lose. Because after Ortega, the argument against waiting periods is airtight. Look, I spend hours every week reading court decisions, tracking Second Amendment cases, and breaking down what they mean for gun owners so you don't have to. The least you can do is subscribe to make sure you never miss a ruling that expands your rights. Subscribe right now. And if you found this helpful, share it with every gun owner you know in the 10th Circuit because they need to know the 7-day wait is dead. Remember, this is educational information based on the 10th Circuit's decision in Ortega versus Grisham. It is not legal advice for your specific situation. Always consult with an attorney if you have questions about gun laws in your state. Stay informed, stay armed, and celebrate this victory for the Second Amendment.